So it's really wonderful to be back here at FGV. I always enjoy my visits here, and I think the timing of this particular visit was quite auspicious because, as you heard, I do a lot of research on anti-corruption law, and including US anti-corruption law, which is probably the best known component of it, that is the Foreign Corrupt Practices Act. And the Foreign Corrupt Practices Act, I think, has been a bit of a model for international efforts to regulate corruption. I think it's been the origin of what I call the new paradigm, the new global paradigm for regulation of foreign corrupt practices. And I see that paradigm being embodied in legislation that you see in the UK, in what the World Bank does, in what Germany does, and now in what's embodied in the new Brazilian anti-corruption law. And so I have questions about that paradigm, and I think this is a good time for you to think about the merits of this new paradigm that Brazil has basically embraced with the new anti-corruption law. Before I start, let me just ask, how many of you are familiar with this area in general? So, for instance, the Foreign Corrupt Practices Act. Okay. And how many of you are dealing with this in the context of practice? Are you practicing lawyers? Okay. Okay, so I won't spend too much time explaining what it does, but I will say a lot about how it's been enforced and in practice, and because I think the concerns that I want to discuss come out of really the practice as it's evolved in the United States and elsewhere. So the basics. The Foreign Corrupt Practices Act makes it an offense to pay bribes to foreign public officials, right? So that's the key. What I want to focus on is not so much that, but the key elements of the way in which it's been applied, right? The elements of what I call the paradigm are, first of all, the idea of corporate liability, the idea that the principal sanctions will be imposed on the corporations that employ or whose agents pay bribes instead of on the individual agents, right? So that's one idea, or instead of on the public officials, the foreign public officials. But the idea of focusing the enforcement efforts and the sanctions on the corporations, that's really quite critical. Secondly, the idea that the sanctions are quite high-powered, right? As many of you know, the reason why the FCPA gets so much attention these days is because the penalties for violations are quite significant. First of all, the monetary penalties can range from, say at the low end, $1 million, right up to $1.6 billion, which is what Siemens paid in 2008. So that's enough to, I presume, get the attention of practitioners, CEOs, et cetera, et cetera. That's why I take it many of you are here, because those sanctions are so high-powered. But the sanctions go beyond just the monetary penalties. They also include the risk of debarment, so the idea that a company that has been found guilty, convicted, found liable for violating the statute can be barred from government contracts for some period of time, right? So in the European Union, there's automatic debarment for firms that are convicted of corruption. In the US and the UK, it's discretionary. The UK somehow got around the EU directive. Right? And I gather it's part of the new Brazilian legislation as well, the provision for debarment. So that's a big concern. Oh, and I should mention also the World Bank and the other development banks have provisions for debarment. So firms that engage in corrupt practices in projects that are financed by the World Bank will be eligible for debarment. And then they've entered into a cross-debarment agreement with a lot of the other development banks. So basically, if you commit corrupt acts in a project that's financed by the World Bank, then the IDB, the Inter-American Development Bank, will automatically debar you as well. So this is another significant penalty for firms that do a lot of business with governments or a lot of business that's financed by one of the development banks. Okay? So those are the two sanctions that receive a lot of attention. But there's a third type of sanction that I think is worth mentioning, which is that firms that are found liable, I think I'll use that term, that are found liable by the US authorities often enter into agreements of some sort, pretrial agreements. They resolve the charges against them through some sort of pretrial agreement with the Department of Justice and the Securities Exchange Commission. that, and or the Securities Exchange Commission, that will say things like, you have to adopt a compliance program, right, an anti-corruption compliance program. You have to train your employees. You have to hire a compliance officer who reports directly to the board. In some cases, they're required to appoint an independent monitor who will report back to the Department of Justice about the firm's progress in implementing its obligations under this agreement. So that kind of direct regulation, very firm-specific regulation, it's a form of sanction because it's difficult for the firms to comply with, and it's somewhat unique in corporate law to this area. This is the main area where these types of agreements have been used. So that's a package of sanctions that I'm calling the high-powered sanctions associated with anti-corruption law. And that model of entering into agreements, having these high-powered sanctions, is one that's global. It's not just under the Foreign Corrupt Practices Act that you see these types of sanctions being used, but the British do it, the World Bank does it, and as I understand, the proposal is that Brazilian regulators will do that too. Okay? Prosecutorial control. Because virtually all these cases are resolved by way of agreement instead of a trial, prosecutors end up not only deciding who is liable by deciding who to prosecute, they also end up setting the penalties effectively. They are essentially performing the sentencing function that we normally think of as being performed by judges, right? So prosecutors have a lot of power in this regime. They're really the people who are driving the regime. And again, you see that in the US, but it seems to be working the same way in the UK and in the World Bank's debarment system as well. So that's another key feature of this regime that I think is worth thinking about. It's very different from the idea of judges or the legislators setting the penalties. It's really being driven and controlled by the prosecutors. And then finally, something that's attracted a lot of attention, especially outside of the US, is the fact that this law is being applied extraterritorially. So the US has been very aggressive in asserting jurisdiction over firms that it thinks have violated the Foreign Corrupt Practices Act. So basically, the statute applies to not just firms that commit acts of bribery in the US. You know, you get on the phone in New York and agree to pay a bribe in Argentina. That's clear. You're also liable, according to the prosecutors at least, if you're a US firm and your employee in Argentina gets on the phone to the guy in the next building and pays the bribe, right? So even if there's no connection to the US aside from the fact that your firm is incorporated in the US, the FCPA applies, right? It applies on the basis of nationality, right? So that's a fairly aggressive way of asserting jurisdiction. But on top of that, it applies to all firms that have securities listed on a US exchange, so long as some act in furtherance of the bribe involves use of what they call interstate commerce in the US, right? In practical terms, according to the prosecutors, this means that if your bribe involves any sort of wire transfer through the US, right? So if you make a payment to someone else that is somehow routed through the US financial system, that's enough to trigger US jurisdiction. So the FCPA seems to apply to just about every bribe that involves a payment in US dollars going through the financial system, right? That's particularly aggressive because then that captures a lot of transactions and a lot of firms that have very little connection to the US. And then finally, in the most aggressive application of the statute, they've applied it to firms whose activities have absolutely no connection to the US except that they were conspiring with US firms. So in one particular case, just to give an example, there was a Nigerian oil project that involved a liquefied natural gas facility being constructed by a variety of firms from France, from Italy, from the US, and from Japan. And they all agreed to pay bribes to various officials in the Nigerian government. The Japanese company was prosecuted under the FCPA simply because it was conspiring with a US firm. They couldn't find any connection between what the Japanese firm did and the United States. They didn't send money through the US. Their officials never had anything to do with the US. You know, they're not incorporated in the US. This is all about a project on an island off of Nigeria. But just because they were conspiring with US firms, the prosecutors argued that was enough to ground jurisdiction in the US. And for reasons that I'll explain later, the Japanese company didn't think it could fight that. Right? The prosecutor's word was final, and they paid hundreds of millions of dollars in penalties. Right? So that's the last component of this regime that I want to focus on. So I'll take them in turn: the corporate liability, the sanctions, the idea of prosecutors having control, and then finally the extraterritoriality. So let's talk about the idea of corporate corporate liability, right? Which is, I take it, novel in the Brazilian context. What's the rationale? The idea is that these types of offenses, offenses committed in an organizational setting, are not just matters of individual responsibility. They're really organizational misconduct. We're dealing with organizational forms of misconduct. Right? So that's the idea, because even if one person ultimately hands over the envelope or authorizes the wire transfer, there's usually a group of other people who either helped them do it or agreed that they should do it or encouraged them to do it or turned a blind eye as they were doing it. Right? So it's really an organizational problem, and it certainly benefits the organization. So that's the theory. Right? But I think the rationale for corporate liability is really a very instrumental one. The idea is that by targeting the corporation for liability, we can get them to help combat corruption, help fight corruption on the part of their agents. And there's several ways in which the firm can do that. It can do it by preventing corrupt activity, right? By not giving people the opportunities to work in places where they're likely to be asked to pay bribes or where they're likely to be tempted to pay bribes. They can do it by changing their reward structures, their compensation schemes, so you don't get bonuses based on getting big contracts from officials in corrupt countries. You get paid maybe a flat rate if you're doing business in, let me pick on Nigeria, for instance. Right? So that kind of, there are those kinds of preventative mechanisms they can take. Or the corporation can engage in monitoring. Right? So it can go out of its way to see whether its agents have engaged in corrupt activity, do the audits, right, collect the data, force people to take vacations so you can go through their records to see what they've been up to, right? And then if you find anything, you can engage in policing. You can actually discipline the employees, right? You can, say, demote them or reduce their bonus, right? So the monitoring and policing is something that the firm is particularly well suited to do. And if it can't do that, because there are always limits to what the firm can do, then they can also report. They can report their employees' misconduct to state authorities who can then punish the employees. Right? And that's an important function that the firm can do. So the firm really is deputized to assist the prosecutors, the state, in either preventing corrupt activity or punishing it after the fact, detecting and punishing it after the fact. And that's very useful in a context where it would be difficult for the state to identify all the people who are involved in paying the bribe or to punish them. Right? So that's the theory. That's the rationale for going after the corporation, to trigger all of those kinds of activities. So what are the concerns? Right? I think the main concern is that you don't want to forget about the individuals. Right? At the end of the day, there's still people who are doing the wrong thing, and you don't want to forget about that. And you don't want a regime of corporate liability to divert attention away from the need to impose individual liability. Right? So that's, in the US, a big part of the debate. There's been a lot of concern that there are 12, 20 prosecutions under the FCPA each year of corporations, and relatively few proceedings against individuals. Right? And there's a concern that it's relatively easy for the prosecutors to go after the corporations, but the individuals are not so easy. Because it turns out that when you threaten someone with going to jail, they resist, they put up a fight. So virtually all of the corporate cases have been resolved by some sort of pretrial agreement, and relatively few of the individual ones have been. The individual cases are the ones that go to trial. So they're expensive for the prosecutors. Right? So they've got a natural tendency to just focus on the relatively easy cases. And that's a problem, because I think everyone would agree that you need to complement corporate liability with some sort of individual liability, but you have to find some way to keep the prosecutors interested in going after the individuals. Right? What are the solutions to that? all I can think of is some way of creating a high-level commitment to individual prosecutions, whether that's having some sort of quota for the number of individual prosecutions or having a separate unit that does the individual prosecutions, which I guess is effectively what will occur in the Brazilian context. So that might be enough to address that problem. But it is a concern, right? Because it really is much easier to just go after the corporations under a regime like this one, where the corporations have virtually no defense, right? Okay, so that's one concern. There's a second concern. I should have said at the outset, and I think Oscar might have alluded to this, my interest in this field flows from my general interest in developing countries and the problems of development and the role that law can play in promoting economic development. Right? So that's why I care about anti-corruption law. I care about the fact that corruption of this kind, transnational corruption, can lead to firms putting workers in buildings that fall down, right? Or bridges being built that will collapse, right? Or pollution, right? Those are the kind of consequences that I'm concerned about. There are other reasons why people are interested in anti-corruption law. Some people are, in the US, are worried just about the competitive effects and so forth, but that's not actually my interest, right? So I'm interested in the extent to which the law actually prevents corruption and the kind of corruption that's harmful to developing societies. Okay. So with that in mind, when I look at a regime that focuses heavily on corporate liability or even individual liability, I wonder, well, what about the other side? You know, a bribe takes at least two people. It takes the person paying and the person receiving. So what about the officials who accept or even solicit the bribes? You worry that a regime that's entirely focused on going after the corporations will forget about and will divert attention from the task of possibly proceeding against the foreign officials who are accepting the bribes. Now, there are some obvious difficulties with proceeding against foreign public officials as opposed to corporations, but they're not insurmountable. It does happen, right? So, for example, in the United States, we do have proceedings from time to time against foreign public officials for their corrupt activity. So, some of you would know about the indictment of Maluf, right? That's under New York state law for receiving stolen property, right? There have been prosecutions of Haitian officials who were paid bribes by U.S. companies, telecommunications officials who were paid bribes by U.S. companies. They're prosecuted for money laundering in the U.S., but it's all coming out of the bribery. Recently, there was a case against an official of the Venezuelan Development Bank, right, Bandes. A senior official of the development bank, it took bribes from a U.S. broker-dealer, right, a U.S. investment company, because they wanted the bank's business. So she routed the business to the bank in exchange for several $1 million worth of bribes, and she was prosecuted. So she was prosecuted along with the people who paid bribes. They prosecuted the bribe payers under the FCPA. They prosecuted her for money laundering and then in a funny way for violation of the New York State statute on commercial bribery. It's an interesting case in its own right. But again, the point is there are legal mechanisms that can be deployed to go after foreign public officials, and sometimes they'll be effective, right? Because there are going to be cases where one country will have the ability to exert power over the officials of another one, right? So because the officials have assets in that country, or so they've got assets overseas, or they want to travel overseas, right? So at the very least, I don't think Mr. Maluf is going to be traveling to New York too soon. In the case of the Haitian officials, they were actually residing in Florida part of the time, as many Haitians do, so they're in jail now. The Venezuelan official was arrested in Miami, right? Because people certainly go through Miami. So it is possible. And again, the concern is that if it's too easy to pursue corporate liability, you'll divert attention away from this other aspect of anti-corruption law, which is prosecuting the officials, right? And it's, again, something to look out for if your concern is using this type of law to actually reduce corruption for the benefit of societies. Okay? The sanctions. So like I said, the sanctions can be significant. Just focusing on the money for a second, last year was a very slow year in FCPA prosecutions, right? There were only 12 proceedings against separate companies, that is. The fines still averaged over $20 million, right? So the US collected $260 million in penalties from under the FCPA in what was considered to be a very slow year. So these are significant penalties. So, and then of course there are the other consequences I mentioned, the potential for debarment and all the terms and conditions in the pretrial agreements. So what's the rationale for these very high-powered sanctions? Well, part of it is based on the theory of deterrence, right? The idea that if the benefits of committing a crime are high, but the probability of being detected and prosecuted are low, then you're naturally going to need very high penalties in order to deter the crime. You're going to need penalties that are at least equal to the amount of the benefit, but actually you're going to need more than that. You're going to have to multiply the amount of the amount of the penalty, amount of the benefit, by the inverse of the probability of being detected, right? So if you're only being caught half the time, you're going to have to make them pay double the amount of the benefit to make up for the other time that they're not being caught. So that's the theory, that there's a low probability of detection, and that's why we need to have high penalties. Okay? Of course, some people would argue that the penalties under US law are not high enough because they're actually capped at twice the gain or loss, right? At least the criminal side. And on the other side, on the civil side, it's still limited to disgorgement. So you may not get past maybe 3 times the benefit under US law, and that might not be enough. It may be that there's less than a 1 in 3 chance of being caught for these types of corrupt activities. But I think a lot of people think of these penalties as high, so let's run with that idea, that these are relatively high-powered sanctions. Right? So why, oh sorry, and I should mention the argument for the compliance programs and the direct regulation, the firm-specific regulation, because that's also quite mysterious. Why are prosecutors getting involved in corporate governance? Right? They're running companies saying, well, you need to appoint this person who's at, just below the board level. Right? It's like really getting their hands dirty and getting right into the boardroom. The argument there is that some companies just aren't going to respond to any penalty, no matter how high, and so they have to take a more hands-on approach. So that's the rationale for that type of, for that aspect of the sanctions. Okay, so does this approach make sense? What are the costs or the risks? Well, the costs are really, if they're too high, you risk putting companies out of business. And putting companies out of business in this economic climate is not something that any state should really be going out of its way to do, right? It destroys jobs, it destroys productive investment, or reduces productive investment, and that's a cost to society, right? So that's a cost that's often borne even in the jurisdiction where the company is located. But the costs overseas can be even more significant. The idea that you're going to start discouraging companies from investing in high-risk countries, right? That's going to be the effect of these sanctions. They're going to engage in prevention. They're going to stop investing in countries where there's a risk that their agents will engage in corruption. That might not be a good thing, right? So, for example, as many of you know, a few years ago, Haiti suffered a tremendous earthquake, right? Haiti is also known for being a very corrupt country, especially, well, at all levels, but that's the perception. There was actually some very serious discussion of whether it would be appropriate to suspend the application of the Foreign Corrupt Practices Act to Haiti for the purposes of encouraging people to invest. The argument was it's not possible for people to invest in Haiti if they're liable to being prosecuted under the Foreign Corrupt Practices Act. It's just, you can't do it. You can't do business in Haiti without engaging in corrupt practices, but at the same time, we want people to do business in Haiti because the society is collapsing and needs this external investment. And it was a real dilemma. Of course, there was no legal way that I can think of to suspend the operation of the Foreign Corrupt Practices Act in relation to one country. But that debate, at least, the fact that people were seriously having that debate, illustrates the dilemma, illustrates the idea that there is a cost to these high-powered sanctions. This idea of deterrence can be taken too far in the sense that it deters what might be socially valuable activities, both in the home country and in the country of the investment. So that's the concern. So what can we do about it? Well, actually, in the US, we may soon, I wouldn't be surprised if there was some movement away from what I'm calling the paradigm of high-powered sanctions. I don't know how many of you have heard about the whistleblower provisions of Dodd-Frank. How many of you, is this, okay, so the people have been advertising. There are now these law firms that are advertising for whistleblowers. I don't know if you've heard about this. So for those of you who haven't heard, I should back up and explain. In the Dodd-Frank Act, the massive revision of the US financial regulation that was passed a couple of years ago, there's a provision that allows the Securities and Exchange Commission to award bounties, basically, of up to 30% of the amounts that they recover to people who provide information. Right? So if you provide information that leads to an enforcement action, and as a result of that enforcement action, the SEC collects, or the SEC or other organizations collect more than $1 million, right, from the defendant, you as the whistleblower get a share of that, and up to 30%. And given the numbers that are at stake in FCPA proceedings, that can be a lot of money, right? So 30% of a $100 million award, that's pretty good, right? A $300 million award, even better. $800 million in Siemens, that's real money, right? So this assumption that the probability of detection is going to remain low for corrupt activity may not be valid for much longer. Because now anyone in the company, all those sales and marketing people, all the people in the back office handling the accounting, sort of papering over the illicit payments, if they figure out what's going on, they have an incentive to send an email to the SEC and try to get a share of the money, right? So we may be moving to a regime where there's a much higher probability of detection, and the same deterrence logic that I mentioned that's being used to justify the current regime would suggest that the penalties should come down significantly, right? So that might be one way to go. And I don't think there's any equivalent in the Brazilian context, but I'd be curious, actually, maybe this is something we can talk about in the discussion period, about whether there'd be any interest in creating a whistleblower program to complement the new corporate liability. Okay, so that's one alternative to the high-powered sanctions. The other one, of course, this isn't doing away with the sanctions, but it is interesting that all these penalties, the $6 billion or so that have been collected as a result of FCPA actions over the past decade or so, it all goes to the US Treasury. Right? All that money, all those fines and penalties, the disgorgement and so on, goes to the US government and stays there. Even though, by definition, the harm, at least some of the harm, is being suffered overseas. Right? This is just the Foreign Corrupt Practices Act. Right? These corrupt practices, you have to assume, are at least in part harming people in foreign countries. So why is it that the amounts that are being recovered go exclusively to the US government? I think if we're thinking about reforming this regime, it would make sense to consider looking at ways of sending some of those recoveries to the countries where the victims are located, right? Either through the state or, if you can figure out how to identify them, to the victims themselves. Right? There are some cases, a handful of cases, at least in the US, where this has been done, but very, very few. It's a tiny amount of money that's been sent back. Other countries have done a little bit more, and the World Bank now seems to be committed to sending restitution back to the state, sending funds that are paid in restitution under their sanctions program back to the state where the harm was committed. But certainly the US practice is to keep the money, right? Might want to think about changing that. What I found interesting in looking at the new Brazilian legislation is that that might be built in. And again, I'm wondering, for those of you who've looked at it, if you look at Article 24, the provision that says that the money, well, at least the penalties that are paid by corporations under the law should be used to compensate the organ of government that was harmed, right? In a case of foreign bribery, I would argue that the organ that's been harmed is an organ or branch of the foreign state. I don't know if that's what was intended by the legislator, but as I read the law, and of course I'm not even an American lawyer, I'm a Canadian lawyer, but as I read the law, suggests that there's a pretty strong argument that funds recovered in Brazil for acts of foreign bribery should be paid to the foreign state. So this problem may not arise in the Brazilian context. Okay. So let me turn to the next issue. Right. This issue of prosecutorial control. Why does this happen? Right. So it's basically because people are afraid of going to trial. It just, corporations, not afraid, but it's not worth their while to go to trial. It's too costly, right? It's costly for the prosecutors too. Of course, the prosecutors find it much easier to just sign an agreement as opposed to going to trial and being forced to present proof of corruption. These are, complex economic crimes, lots of evidence, paper, that's a big deal to go to trial. So there are obvious costs for the prosecution. That's why they prefer a pretrial agreement. On the firm side, you've got all those costs as well, the direct costs of trial, right? And there's little benefit. They have almost no chance of winning, right, under this regime of where any act of their employee is attributed to them. And if they go to trial and lose, then they have the risk of debarment, certainly in the European Union. And also, over the course of the trial, there's bad publicity, right? Every day that the trial goes on, there's going to be a reporter there, at least in the big case, and you won't just have one bad news day, the way you do with an agreement, but you'll have lots of bad news days. So that's why, from the firm's perspective, trials are very costly. So there's a deal to be made there. Prosecutors don't want trials, firms don't want trials, that's why we don't have trials, but that means everything is settled through these agreements, and the prosecutors and the firms work out the terms of them with relatively little judicial oversight. The worry there about prosecutors really shaping everything without that kind of oversight is it's not clear that prosecutors' interests are fully aligned with the interests of either the jurisdiction where they're employed or the jurisdictions where the victims are. Because prosecutors like easy cases that are high profile, right, for sort of obvious reason. I think that's, I'm not speaking out of turn in asserting that. Those are not necessarily the cases that are most important in terms of things like development, right? So prosecutors might choose to go for, what the US prosecutors do is they pick industries, certain industries, and they make sweeps. So they'll do oil and gas and do 10 oil and gas cases in a row. And it's easy for them because they develop expertise and they go after one firm, that firm explains, okay, here's what we're doing, we'll settle with you, and by the way, here's what our competitors are doing, and they get tips and so on and so on. They just work their way down the chain. Just bang, 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 right? Relatively straightforward. But prosecutors, the resulting pattern of enforcement may not be what would be optimal from a social perspective, right? So you can imagine a very different way of doing things where, say, the US prosecutors would ask different countries, well, where's your corruption problem? What should be our priority? Right? So they could go to Angola, and the Angolans could say, well, it's infrastructure. They could go to Haiti. In Haiti, they would say, it's customs. They could go to Argentina. They would say, well, it's healthcare, maybe, right? In some places, it might be oil and gas. Maybe they'd say that in Nigeria, maybe not, right? So that would be a very different process where the priorities would be set, the enforcement priorities would be set not just by a bunch of foreign prosecutors, but in consultation with the affected societies, right? Going further, you could say, well, we're not going to prosecute at all. We might collect evidence when we get one of these tips and then refer it to the local prosecutors, right? We'll refer it to the Haitian prosecutors, refer it to the Angolan prosecutors, et cetera. Or if you don't trust the prosecutors, but you trust the courts, you would actually think of proceeding directly in the foreign courts. I'm just throwing these ideas out there, but just to highlight the fact that it's a little strange to have the anti-corruption strategies for a lot of countries around the world being decided by a handful of prosecutors in Washington, D.C., basically, right? Okay. The last issue, the extraterritoriality. I explained basically how it works, that there are very, very few limits on U.S. jurisdiction under the Foreign Corrupt Practices Act, at least according to the Department of Justice and the Securities Exchange Commission, right? That's just been their practice. And it hasn't been challenged very often because none of these cases go to trial, right? So that Japanese company I told you about that was prosecuted because it conspired with the Americans in the Nigerian project, they just couldn't risk going to trial, they felt. It's a massive engineering company. The risk of being convicted, getting a real conviction as opposed to the sort of agreement they got, would have been too serious given the risk of debarment. Right? So they just couldn't afford that kind of risk. They went to trial. They settled without challenging the jurisdictional claim. Right? Why do we do this? Well, internationally, under the OECD Convention, there's been a real push to have countries assert jurisdiction very broadly. Right? This way, lots of different countries are in a position to prosecute a company. Right? And if you start from the premise that anti-corruption law was not being enforced enough, it makes sense to try to increase the level of enforcement by giving lots of people the opportunity to enforce. Right? So that's, I think, the rationale behind doing this. Right? The problem is that there's really no formal mechanism for coordinating the enforcement activities of all these different countries. Right? And this is, I suspect some of you know, a bit of a nightmare for companies. Right? If you are a company that's paid bribes around the world and you're also a multinational, right? So let's say you're a Brazilian company doing business in a set of African countries, maybe a little bit of business in Asia, a lot in the rest of Latin America. Of course, you're liable to be prosecuted, and you've got shares listed in the United States, let's say, right? Possibly in Europe. And some of the business is conducted by subsidiaries in a bunch of other countries, right? You're now liable to be prosecuted not only by Brazil, but by the U.S., by all the countries where you're actually paying the bribes, the countries where your shares are listed, besides the U.S., and any other country the money passed through, right? So you want to settle, right? You want to reach some sort of agreement. You don't want to go to trial, etc. What you have to do is reach a global agreement, right? Otherwise, what you'll end up doing is you'll settle with the U.S. Department of Justice, and they will issue the press release. They'll publish this agreement where you agree to a whole set of facts saying, here's what I did in Angola, here's what I did in Mozambique, and so on. The Brazilian authorities will take that press release and take that statement of facts and use it as a roadmap to their own prosecution. That's your concern, that if you can't get a global agreement with all of the potential regulators, all the jurisdictions, then they'll just come after you one by one, right? And you'll end up paying over and over and over again, because not only is there no formal way to enter into this sort of global agreement, there are no legal rules that limit the jurisdiction of, say, the subsequent countries. There's no ne bis in idem principle. Right? There's no double jeopardy internationally in a lot of jurisdictions. So you could literally end up being prosecuted twice, 3 times, and so forth. So that absence of coordination mechanisms is a problem. It leads to the risk of over-enforcement that I identify on the slide. Of course, there's also the risk of under-enforcement, which is that since everyone can prosecute, no one will want to be the first one. They'll all say, well, let the other guys go first, and let them do the work. Right? It's hard to predict which way it will work out. Either way, we know it's not optimal. Right? And so I think going forward, especially because of pressure from firms, we'll see a lot of attention being paid to mechanisms for at least ensuring voluntary cooperation, mechanisms for helping people helping firms are not people, helping firms enter into these kinds of global agreements. Right? So that's one direction that I think I'd actually predict that we'll see that. You could imagine a legal solution as well, sort of jurisdictional rules that, you could have double jeopardy rules being adopted and so forth. Or what I would advocate for is some sort of complementarity principle, right? That, coming back to my development focus, some way to make sure the interests of the victim country are protected and respected, right? Some way to say that, well, the prosecutors in the country where the bribes were paid, they get the first shot at the company, not just the official, but the company that paid the bribes. If they're not willing to make a genuine effort, then okay, the foreign actors can get involved, right? But, you know, if it's Angola, Angola should have the first crack at Petrobras, right? And only if they are unwilling to proceed or unable to proceed, will the Brazilian authorities move forward. That kind of principle, the adoption of that kind of principle, would, I think, make a lot of sense if you're concerned about the broader development implications of this, okay? The effects of this kind of regime on the host countries. Okay. So those are the key elements of what's being done that I wanted to highlight, and why I think there really are some issues around, some questions to be asked about whether this is a worthwhile paradigm. But ultimately, whether this is the right direction to be going in, whether this is the right model or not, I think is an empirical question, right? Or at least in part an empirical question. And so that suggests there are a whole bunch of questions we need to ask, that we need to answer before we can decide, you know, is this model working, or should we be pursuing any of the alternatives that I've discussed, right? So we need to ask, well, we need to figure out exactly how is the law being enforced. So we just need basic data on that. Then we need to know, well, what do people think, how do people think it's being enforced? Then, well, and what are they doing in response to that? And then what are the consequences? What is this doing to the level of corrupt activity? And of various types, you know, in various sectors, various levels of government, high level, low level, and so forth. You know, if we really want to understand how the law is working and what effects it's having, and do it in a systematic way, those are the kinds of questions you have to ask. And then ultimately, I think we should be asking, well, what are the effects on society and the economy, right? So we don't have that information, and people don't seem to be that interested in collecting it right now. There's a lot of data on, quantitative data on the prosecutions. We know that. I can tell you exactly how many proceedings have been launched under the FCPA, how much they've collected, where the firms were based. I've got a whole database of that, right? And I can do a statistical analysis of the way in which the law is being enforced, right? We don't have much on people's perceptions, and we don't know much about how firms are reacting. And so now I'm going to speak to the academics in the room. This would be a perfect time for people to start, for researchers to start doing qualitative research inside firms to look at how they're reacting to the new law, right? How are they changing their practices, right? How are they changing their attitudes towards overseas bribery? To do, you know, and to, I could imagine an ethnographic analysis where you start following people and just over the time and over the next 12 months, seeing how their attitudes towards foreign bribery change, right? I think that kind of research will be particularly valuable. And then, of course, we need better data on the prevalence of corruption. We have these perception surveys, right? They're not terribly useful. We have slightly better data on perceptions of bribe paying by country and by sector with the Transparency International Bribe Payers Index, but it's not so great, right? And I know it's hard to measure corruption, but we could do a bit better, right? So there's room for that. And then, of course, the effects, right? And that's the last stage. And that's easy to collect in a way, but tracing the connections, tracing the causal connections between the way the law is being enforced and what firms are doing to the level of corruption and to the broader economic effects, that actually requires very rigorous empirical analysis and theoretical analysis. And so, again, speaking to the academics in the room, I think this is a perfect time to be doing that kind of work in Brazil, just like it's a great time to be doing it everywhere else in the world. Okay? And I think only once we have that research will we have a sense of whether this new global paradigm really makes sense for any country, including Brazil. So that's what I wanted to say. With that, I'll close and turn it over to my commentators. So, thanks.